We're going to go ahead and get started. Thank you for attending the St. Joe County Bar Association Local Practice Seminar. You've probably heard this enough times, but I'm going to say it anyways. Please remember to fill out your blue CLE certification form before you leave, otherwise you won't get your CLEs. Also, as a courtesy to the speakers, please silence your phone, put it on vibrate or something of that nature. Also, if you would like to use the internet, we have Wi-Fi under H Honors, and the password is 1981. Also, at the end of this presentation today, we will be showing a short documentary on the history of the St. Joe Bar Association. So if you'd like to stay, please do. It takes about 10 to 12 minutes, so it's not very long if you would like to watch that. And for our presentation, we have Shannon, Buari, and Dick Nussbaum, who are presenting today on NIL. Mr. Nussbaum is a proud Notre Dame alum who is now a member of the Board of Trustees at the university and was once the president of the Notre Dame Alumni Association. His philosophy when it comes to practicing law is to earn the trust and respect of the people he works with and obtain the best possible results for his clients with integrity, professionalism, and efficiency. Mr. Nussbaum is, I mentioned, a proud graduate of the University of Notre Dame for undergrad in 1974. He studied English and graduated cum laude. He also stayed at Notre Dame for law school and graduated in 1977. He was in varsity baseball and leading hitter on the team in 1973. He is now a partner of his law firm and continues to provide services to the community. We also have his plus one. No, I'm just kidding. Shannon Buari. That's a joke that they just said, and I just stole it from them. Shannon Buari is an associate at Anderson, Augustino, and Keller, and I've trained him very well as an associate there. He is from Columbus, Ohio. He has a wife and 4 kids. He graduated from Eastern Michigan University. He went to law school at Valpo and has been practicing in the areas of estate planning, trust formation, executive compensation, employee benefits, and other. And I will now turn it over to the both of them to entertain you for the rest of the day.
Thank you, Myra. First of all, I want to make sure that I thank, on behalf of myself and Shannon, the entire committee for this seminar. I know that it is a large, lengthy, and challenging task. I think this Bar Association does it better than anybody in the state. I've tried to attend each of the sessions, that one of the 3 for each of the sessions, and they've all been well done. So can we give a round of applause to Myra? So you might ask, why am I speaking to you right now? It has to do with college athletics, and you did hear that I was a long time ago a college athlete. There's really no proof of that direct, so long ago. But for the fact there are 2 members of the Bar Association who could attest by direct testimony that I did play baseball at Notre Dame. And one of them is here. I will tell you, I saw him perform at Notre Dame much more than he saw me perform at Notre Dame, and that's my friend and classmate, Jim Masters. And I have a little gift for you, Jim. So who was the second? Anybody have any idea who the second might be?
Tony Zappa.
Who said that? Pete Augustino. You're right. You're right, but I'm not going to give you a ball, Pete. I'm sorry. I'm going to give Tony's brother Mario the ball. So that ball has an important role to play later in the program. But But that's not the reason why I'm speaking to you, that I was a baseball player. The second reason you might think is that I have extraordinary technological skills and can hold audiences riveted by virtue of the PowerPoint presentation that you're going to see, or that part of this presentation involves antitrust jurisprudence. And I know that the first thing you think of when you think of antitrust is Dick Nussbaum. So that's not it. The third reason might be, frankly, that Amy and the committee felt sorry for me because I celebrated my 46th anniversary of practicing law in this community last month, and I've never been asked to do this, so I think they were trying to get to me before it was too late, but that's not it. The reason I'm doing this, and I attribute it to Mitch Heppenheimer, and I thank you, Mitch, for thinking about me. I had a professional opportunity to form what's called a collective. You'll hear more about that. It's an organization that tries to accumulate funds to pay out to student athletes for their name, image, and likeness. What I didn't know was that many of these collectives are 501c3s, and that's something that I had done. And so there were some former athletes that asked me to use that skill for whatever it was worth to form a collective. So that's really the reason why. But the real guts of this presentation, if you can hang in there with me for a while, I'm going to do kind of an overview of things. Is Shannon, who's actually practicing in this area. And this has been around for a little over 2 years. So the fact that we have a member of our bar association so ingrained in this particular field is something that is quite remarkable. So let's keep going here. So the overview, the crucial case, and Shannon's going to get into the deep dive on this, is the NCAA versus Alston case. There's also a case prior to that, NCAA versus Board of Regents, which I will talk about a little bit. There was, in the Alston case, there was some language in the opinion that led many to believe that this opinion, which although it related to college athletes, was going to be somehow applied to the baseball antitrust exemption, of which I do have a little bit of knowledge about. It is an incredibly arcane, head-scratching concept that Major League Baseball is exempt from the antitrust laws dating back to 1922. And so I had prepared a little bit about that because I'm a little bit more comfortable in that area. And that didn't go as well as I thought it was going to go for the reasons I'll get to in a minute. So the next item is the collectives, which I've already talked about. The 501c3 tax-exempt status of collectives is in jeopardy, as it probably should be, and I'll talk a little bit about that as well. So this is about the fourth version of my presentation because it seems like every day something changes. On October 17th, there was a hearing before the Senate Judiciary Committee on this very subject, and I would encourage everyone who has any interest in this to go on the Senate Judiciary Committee website. It's a fairly long hearing, but pretty interesting. So I'm going to show some snippets from that here because I think it will be very instructive as to what's going to happen in the future. There's going to be federal legislation. We just don't know when and what it will look like. And then I've already mentioned the fact that baseball was involved, and there's a case that was pending before the Supreme Court involving the baseball antitrust exemption, and I was going to talk a little bit about that. So, as I said, Shannon has much more experience in this area than I think anybody in this room. And he's going to go into a deeper dive in the Alston case. He's going to talk about what the NCAA did in response to the Alston case. They developed some rules. He's going to go over some trends. He's going to go what you can do under NIL, what you can't do under NIL, and then we'll open it up for questions. And so my technological skills are, so that's why Shannon's on the call here. So I mentioned that there's been some antitrust cases involving college athletics, and probably the most significant prior to Alston was the NCAA versus Board of Regents of Oklahoma University. It was a 1984 case. Interesting background on that. First of all, the NCAA is the National Collegiate Athletic Association. It is an association of universities and colleges. The members are the university presidents, so technically it's not an athletic association made up of athletic directors, it's the presidents. I don't remember what the total count is, but it's in the hundreds, and its headquarters are in Indianapolis, and it probably is one of the least efficient organizations in the history of mankind, in the sense that it's got a lot of rules that are hard to follow, and this whole NIL issue, in part, where it is right now, and why it's the Wild Wild West, as we call it, is because the NCAA was kind of sleeping on its hands and hoping that the status quo would stay where it is. So the first time the NCAA got its wrist slap was in this Oklahoma decision, and that involved media rights. Most of you, some of you, may recall the fact that back in the early 80s, 70s, and before, the NCAA controlled who could be on television. So, for instance, Notre Dame, Ohio State, some of the larger institutions that you might see every Saturday, would only be permitted one time during the football season to have a national broadcast. And then there were 3 other times they could be on for regional broadcasts. That was the rule. So there might be, an Oklahoma State game, which is a big rivalry that might not make the national broadcast because Ohio State was playing Michigan. The 1966 game of the century between Notre Dame and Michigan State that ended in a 10-10 tie was not seen by the entire country, believe it or not. This Saturday, you'll have so many choices about what you want to watch. You won't see Notre Dame this Saturday, but you'll be able to see just about everybody else in the country. And that's because the NCAA lost a case that said you can't do that. That's against the antitrust laws. And so what happened was the conferences, the various conferences, had assigned to them from their various member schools their media rights, and the conferences have since gone out and made deals with ESPN, CBS, Fox, NBC, and literally billions of dollars is now flowing into the coffers. So there's this huge amount of revenue that's coming in, and NIL is in fact part of that discussion in terms of the fairness of where that revenue is going. We hear about the $10 million per year coaches' salaries. We hear a lot of money going places, but none of the money was going to student athletes. And that's why the Alston case went up to the Supreme Court. There's an interesting tie to the Bar Association, and I believe Tom Sopko was involved with this, but back in the early 80s, I said that it was only one time Notre Dame could be on national television and they could only be on regional broadcasts. Well, there was kind of an unwritten gentleman's agreement that Notre Dame could broadcast their games locally through WNDU, and I don't know whether that fell through the cracks or whatever, but the NCAA found out about that, and I think we were going to play Purdue, and it wasn't going to be televised, and this community was in an uproar. And so some of our local lawyers, Bob Lee was one, I think Tom was another, and Tim McLaughlin, those are who I remember. decided they were going to file an injunction against the NCAA, and they filed it. And they filed it in Judge Montgomery's courtroom. And they were feeling pretty good about the result of that legal action, and all of a sudden, the NCAA was in Kansas City at that time, and all of a sudden the big suits from Kansas City showed up. And I remember they met back in the jury room in the circuit court, and the NCAA figured out pretty quickly they weren't going to win this injunction. And so they granted the right to Notre Dame to be able to televise those local games. So it's an interesting thing that our bar association was involved in that particular issue. So the Alston case was a group of former student athletes that were challenging the NCAA rule as it relates to scholarships. That's a highly regulated area. In other words, what the NCAA could provide in terms of scholarship assistance, how many scholarships per sport there could be, and it's probably even more onerous in terms of what you couldn't do. And the plaintiffs in that case, in the Alston case, felt that it was only fair for the athletes to be able to share in this $1 billion of assets that were being into the pie of NCAA athletics. So I'm going to go through this really quickly because Shannon's going to do a deeper dive. There's a 9-0 decision. Not a lot of 9-0 decisions coming out of the Supreme Court against the NCAA. And it did a number of things, but I pointed out two. When I say preserve the 11.7 rule, in the current baseball, college baseball world, each school is entitled to 11.7 scholarships. And I think part of that has to do with Title IX, but that rule was preserved. So the limitation on the number of scholarships per sport survived. What it did do was, in addition to expanding postgraduate scholarship opportunities, which was an educational related benefit, that was severely limited. Believe it or not, the school could only give 2 $10,000 grants to student athletes who were going on to do postgraduate work. And so that's been expanded dramatically, which was a very good thing. The NCAA read the tea leaves. They figured it was only a matter of time before this NIL situation was going to be validated by the Supreme Court. So they established some interim rules about a week or so after the Alston decision, and Shannon's going to walk you through some of those guidelines. Collectives. So as I mentioned earlier, I was asked to help form a collective. And a collective is both a for-profit and a not-for-profit corporation where monies are pooled so that there would be a fund that could pay athletes for their name, image, and likeness. Part of the situation right now is that the schools cannot do that themselves. It's part of the NCAA rules. So Notre Dame can't pay any athletes for name, image, and likeness. And the problem is that there's the collectives are all known kind of by the schools. So you will hear, for instance, IU has a collective called the Hoosier for Good, and I'll talk a little bit about that in a minute. But what's happened out there with these collectives is that in Utah, every single player on the Utah football team, everyone, whether they play or they don't play, so close to 100 athletes, each one of them has received a brand new pickup truck. So when Utah has given everybody a pickup truck, USC's thinking, we'll give them 2 pickup trucks. But, that's what we're talking about, the Wild Wild West. Those are the kinds of things that are happening out there. Interestingly, the person that has gotten the largest NIL deal is a gymnast from LSU. Her name's Olivia Dunn. Tremendous gymnast, and that's really one of the great things about NIL. There's been a number of positives, is that women have an opportunity to cash in on their work or their sport, even though they're not going to go on professionally and do things. So Olivia has worked out a huge deal. Recently, Sam Hartman at Notre Dame, you might have heard that Under Armour had renewed its contract with Notre Dame, and it's really important, even though I do serve in the board, I have no inside information on any of this from the university, so if you are thinking that I'm providing you with some inside information, I am not. If I knew it, I wouldn't tell you, but I don't know it, okay? So I'm basing this information on what's known publicly. But Sam Hartman also benefited either through the Notre Dame contract or outside of the Notre Dame contract. I'm sure that's probably the way they did it with Under Armour. So Sam, on his own, has provided swag, Under Armour swag, to each of his teammates at Notre Dame, which was a nice gesture on his part. But he and I don't know the number that he got, but it's probably a very substantial number. As I mentioned before, these collectives all over the place became 501c3s. And if any of you have gone through that process and applied to the IRS to get tax exempt status, it's not a slam dunk by any stretch of the imagination. I've done a number of those. There's usually a lot of back and forth. What happened in this situation, it went through faster than I ever saw it happen before. It was less than a month. And I was just blown away because I'm thinking there's no way that this is going to work, because what you're supposed to be doing with a 501c3 is benefiting some charitable purpose. And the theory behind the first one that I became aware of, and that's the Hoosier for Good 501c3, and was to benefit IU athletes. And Fred Glass was the individual who did that one. Fred was a partner at Baker Daniels and was head of the Indianapolis Sports Authority and became the athletic director at IU. And after he retired, he got involved in these collectives. So it was very well done, and the theory behind that was there are a lot of athletes out there that aren't quarterbacks on the football team, aren't going to be able to share in all this money. And wouldn't it be nice if individuals could donate to these collectives, get a charitable deduction, and then you can use that money. So for instance, an organization like the Center for the Homeless that might be promoting some event, could have an autograph signing session, and this collective could pay the athletes for their time, which is not going to cost the Center for the Homeless, and money generated from that would certainly help the center. So, and the athletes would benefit in some fashion. Well, that would work if the athletes were getting paid in the thousands of dollars, not in the hundreds of thousands of dollars. But these collectives have somehow in the not-for-profits, tax exempts have gone beyond what's reasonable. So the IRS came out in May, and they basically came up with the idea that this is not kosher. And they came up, this is at the tail end of their opinion from the Office of Chief Counsel. They've signaled that the private benefits they provide student athletes are not incidental, both qualitatively and quantitatively, to any exempt purpose, and they're right. Okay, I mean it's problematic, and they probably should be doing what they're doing. So, but what's happening now, since the message is out there, but it's still a tax exempt organization, is that schools or the collectives that are helping to support schools are out there pushing as hard as they can, as long as they can, to get as much money put into the collectives. So that's something to be looking for. You know, we're talking about what's going to happen next. I think that's something that's going to be on the horizon pretty quickly. I mentioned about Alston's impact on baseball. The Athletic came out with an article October 26th, where the headline is, "The challenge to MLB's antitrust exemption nearest juncture, and as I said, the antitrust exemption for baseball is over 100 years old. It's been up to the Supreme Court a number of times. The Supreme Court hasn't overturned it, but in the Alston decision, there was language in there that certainly signaled that they were open to considering that. So, in this athletic article, there's a quote, "The Supreme Court's unanimous decision that paved the way for NCAA athletes to make money from their names, image, and likeness changed everything." And one of the changing everything was NCAA versus Alston has baseball's antitrust exemption in the court's sight. The case presented itself to do so involved the Major League Baseball takeover of minor league baseball. And that goes back to the two baseballs that I sent out. So one of the things that Meyer did not mention that I had the privilege of doing since 1993 through 2020 was that I was the general counsel for the Midwest League, and then I became the president of the Midwest League in 2014. One of the things that you got when you became president of the league is they put your name on the baseball. And so the baseball I gave Jim and the baseball I gave Mario to give to Tony has my name on it. Okay, that's really cool. That lasted for about a year or two, and then because it costs more money for Rawlings to print the individual, there's 17 leagues, so they had 17 different sets of balls, and they were going to charge a premium for it, so most leagues, including the Midwest League, said, "Dick, it's been nice, but we're not going to pay the extra money for your name on the ball." So the balls that I just gave out are collector's items. Someday they may be worth the Honus Wagner baseball card, which is millions of dollars, so hang on to them. But the reason why I'm no longer the president of the Midwest League is because Major League Baseball came in and basically had a hostile takeover of minor league baseball. And they came in, and why did they do it? Because they could. There was an agreement between the major leagues and minor leagues that had been in existence for 100 years, and Major League Baseball said, "You know what, we don't want to do this anymore." And supposedly there were some negotiations. At the time, I was the president of the Council of League Presidents because the New York Penn League got terminated. And the president was the president of the New York Penn League, Ben Hayes. I became the president because I was the vice president. So I was privy to some of the negotiations, or I'll put negotiations in quotes. There was a lot of rope-a-dope going on until September 30, 2020, and the professional baseball agreement between the major leagues and minor leagues ended. And the impact of that was affiliated minor leagues went from 160 teams to 120 teams. So there were actually 42 communities that lost their affiliated baseball. And they weren't very happy about that, the 42. And so some of the teams sued. And there was a case that was going up to the Supreme Court. And there was a writ of certiorari, or however you pronounce it, pending. There was an amicus brief filed. And if you could look at this amicus brief, this is a historic document. Because if you look on the left side where the counsel are, you'll see the name Matthew Nussbaum. And that was the first time in the history of the Supreme Court, 200 and some years, that the name Nussbaum appeared on a document before the United States Supreme Court. That's my son, Matt. Matt is the general counsel for the Major League Baseball Players Association, and they were very interested in this particular case and filed a brief on behalf of the plaintiffs, the minor league teams that got eliminated by Major League Baseball. So I'm all excited. I said, this is great. My son's going to be up there before the Supreme Court. You know, these ruthless people from the commissioner's office are going to have their lunches handed to them. And so November 2nd comes along, and Major League Baseball settles lawsuit. So avoids Supreme Court challenge to historic antitrust exemption. So Major League Baseball basically went in and bought this case out. I don't know what the settlement was. My educated guess, it was probably in the neighborhood of $30 million to pay for the loss of the value of these two minor league teams and for the attorney that was involved. That's my guess. So there's a lot of discretionary income in the commissioner's office to be able to do things like that. And what's interesting too, if you look at the baseball, you do not see my name on it, you see Rob Manfred's name on it. And so Rob Manfred's name's on every baseball now in minor leagues and major leagues, which is to my chagrin. So I mentioned earlier that there was a testimony that was taken by the United States Senate on October 17th. And what I didn't know about these seminars was that the presenters were not only supposed to present, but they were supposed to make up the name. And so Shannon and I came up with the name of Wild Wild West. And what Shannon and I didn't do was we didn't trademark that name. And I'll show you in a minute why that's too bad. Okay, Shannon. I got some videos that we need to. See how hard that was?
Across the board, I'm hearing real concern about the state of college athletics right now, that it is the Wild West.
It sounds to me like we do have a bit of wild, wild west.
In college sports, it's now being threatened, in my opinion, by a lot of the Wild Wild West.
Wild West is exactly the right term to characterize where we're going.
It's the wild, wild west out there.
So I'm pretty proud of that.
Across the board, I'm hearing
So we're going to show some snippets from that testimony. And one of the things that...
We all know
Go ahead.
today that this system of college athletes is in need of reform. That's why you're here. It's in need of reform now, which is why we're here. The system all too long and often has been exploitive and abusive financially, emotionally, physically. And we have had a number of hearings in other committees, Commerce Committee, as well as this one. The system, very simply, has been far more focused on profits than protecting students, and it has failed to safeguard them against the abusive and often exploitive system that takes advantage of their blood, sweat, and tears in creating a $16 billion industry. Make no mistake, it is a $60 billion or more industry that is fueled by the blood, sweat, and tears of these athletes. And all too often, they fail to benefit from it.
We meet today with the world on fire. To my Democratic colleagues who have been very good to work with in trying to find a response to this horrific attack by Hamas against Israel that will make the world a better and safer place. So as we talk about one of the more fun things in American life, college sports, I just want to let everyone out there know that this committee is working hard to try to find a way to be helpful. In terms of being helpful, where I come from, South Carolina, and many people on this side, college football is not a sport, it's a religion. And we're very concerned about where this thing is going. I think there's a lot of bipartisan support. There needs to be a national standard. All of your schools need to have some guidance that applies to everybody all the time. I think if you make college athletes employees, you're going to knock out sports programs for Division II. A lot of non-revenue generating sports, particularly in women's athletics, will go away. As you try to elevate some of the star players to make sure they get a piece of the pie, we don't want to create an environment where Division II or smaller Division I schools will be knocked out of the game because they can't afford it. I want it still to be an amateur sport to the best that we can. So to me, I want to associate myself with what Senator Blumenthal said. There needs to be a federal standard. Utah is offering everybody on the team a new truck. There's no end to this. You know, donors are out there competing ferociously and pro sports, you sign a contract. That means somebody's going to take that player away from you for a certain period of time. You got a chance to get your money back. Between the portal and NIL, college football is in absolute chaos.
My name is Walter Jones, and I'm the Executive Director of the Growth Collective, representing student athletes at the University of Mississippi. And I'm also a founding member of the TCA, or the Collective Association, which is comprised of 25 collegiate collectives from across the Power 5 landscape, serving as advocates for over 50,000 student athletes in 25 sports. Our goal is to serve as a unified voice to shape the development of the NIL market in college sports by creating a sustainable model that gives student athletes the ability to maximize their NIL platforms. Current data shows that collectives are responsible for approximately 80% of the money being paid to NCAA athletes through their NIL activities. Given this figure, the TCA is unique in that our members possess and are willing to share our first-hand knowledge of how NIL is working in your local communities, and we seek to partner with anyone who wants to produce well-informed and effective legislation benefiting collegiate student athletes first. Unlike all our stakeholders in college sports, we work with everyone in the ecosystem by sitting at the point of intersection within NIL commerce. Before we delve into the substance, let me be very clear about one thing. Our organization and I are extremely bullish on college athletics. Are there aspects to the current model that need addressing and evolving? Of course. But the overwhelming majority of commerce with name, image, and likeness is positive. As a student athlete in the late 90s, I can tell you that today's student athletes have the resources and ability to deal with the realities that inevitably come to them in life. Whether they play professional sports or not, athletes now have the ability to solve for socioeconomic issues, stay in school longer to further their academic careers, locate the best possible competitive situations athletically, and be a more functional contributor to society when they leave their respective campuses. Finally, as TV viewership continues to break records each weekend in the college football season this year, and this past spring with March Madness and basketball, the marketplace for athletes to maximize their value has never been stronger. The NIL landscape continues to experience the inevitable growing pains of any free market model, but the overall health of college athletics is strong.
Especially for the Columbus.
At St. Joe's, we're not waiting for an NCAA rule to tell us to protect the health and safety of our student athletes. We do so because it's the right thing to do and it's fundamental to who we are. We employ dozens of individuals whose sole job is to support the physical and mental well-being of our student athletes and their academic success. Finally, outside of team travel, our #1 operating expense is student athlete insurance premiums and medical expenses. I hope that you will agree that athletics is working quite well for student athletes in institutions like St. Joe's. In my opinion, the primary crisis facing college athletics is the threat of our student athletes becoming employees. I practiced labor and employment law for 15 years before getting into this line of work. I do not believe employment status is the answer, and nor do our student athletes. They don't want to have to apply for posted positions when what they're really going for is an education. They don't want to go through the state work comp system for their injuries. They don't want to punch a time clock worried about what might be compensable time under the FLSA. If our student athletes are deemed employees, we will transition their financial aid to wages in order to stay competitive. The taxation differences between wages and tuition are extreme and not in favor of our student athletes. Our 51 international student athletes want to compete, and they would not be able to do so as employees due to their F1 student status. For these reasons and many more, I am passionate about the granting of special status to student athletes that would confirm that they are not employees of their respective institutions. On the other hand, we desperately need reform when it comes to NIL. Like most athletic directors, I've always been supportive of student-athlete NIL. The legitimate endorsement deals like those obtained by Ms. Thomas are awesome, especially for women who have limited opportunities in professional sports and whose value peaks during their college years. Unfortunately, the current NIL situation is untenable for 3 reasons. #1, NIL collectives are engaged in bidding wars for the attendance and retention of student athletes. Number 2, under current rules, Title IX does not apply to collectives, resulting in a disproportionate percentage of collective dollars going to male athletes. And number 3, the patchwork of conflicting state laws governing NIL are confusing to everyone, especially the student athletes, and create a profoundly unequal playing field.
One more.
What defines the unique American model of intercollegiate athletics, and to be clear, it doesn't exist anywhere else. It's a club system everywhere else in the world, is the integration into the educational institution. It is the opportunity to have all of the same rights and privileges as any other student. And if you put them in a separate category with all the consequences that have been articulated here, that goes away immediately. And we no longer have the model that we understand as intercollegiate athletics today, and fundamentally separates us from the educational value. The vast majority of student athletes are not going on to continue their sport after they leave college. It is the education which is the primary value of their experience. We have to protect that. We have to protect their ability to be admitted under the same standards, to be educated under the same standards, and to learn under the same standards. If you take that away, you do enormous damage to those current students.
So I'm going to turn it over here to Shannon in just a minute. You can see there's bipartisan support for federal legislation to do two things. One doesn't have anything to do with NIL, and that is the employee status that is trying to be students. Certain individuals and organizations are trying to get student athletes to unionize and get an employee status. And Jill Bodensteiner, who is practiced in South Bend at Notre Dame for quite a few years, is now the athletic director of St. Joe's, and Jack Swarbrick obviously are very passionate about that. So there's going to be federal legislation at some point in time. What's complicating things was last night. President Biden met with some former college athletes, and the White House is now actively involved in this issue. There's a good thing to that. There's a bad thing to that, because you see all the bipartisan support on the Senate, and when the president becomes involved in things on an election year, things become more political. So hopefully that won't distract from the necessary federal legislation that should be forthcoming, hopefully within the next year or two. So, Shannon, thank you.
I didn't bring the baseballs, but hopefully you'll still stay engaged. So now we'll just talk about what actually is NIL. NIL is actually the name, image, and likeness, or NIL, are three elements that make up the right of publicity. The legal concept to prevent or allow the use of an individual to promote a product or service. So in a nutshell, student athletes are now allowed to make money from their personal brand. Brief history. In 2019, California enacted the Fair Pay to Play Act, which was going to allow college athletes to be paid for their name, image, and likeness. It would make it illegal for the state of California or any universities in California to revoke an athlete's scholarship or eligibility for taking money for their NIL, and it was to go into effect on January 1st of 2023. In June of 2020, Florida enacted the Intercollegiate Athlete Compensation and Rights Act, and what it did was it established a right, it established the rights of student athletes and the right to earn compensation for the use of their name, image, and likeness, and the responsibilities of their post-secondary educational institutions. Like Nussbaum has alluded to, June 21st, 2021, NCAA v. Austin, a decision was released, but prior to NCAA v. Austin, another monumental case in the NIL space was O'Bannon v. NCAA. And O'Bannon was a former UCLA basketball player who eventually sued, him and a couple other former athletes, sued the NCAA for using their name, image, and likeness in video games and other marketing. And the NCAA was required to pay out a lump sum of money to these plaintiffs, just to keep it brief. But for any video game buffs in the room, like myself, the O'Bannon case is the reason the NCAA actually severed ties with EA Sports. So they no longer make the NCAA football nor do they make the NCAA basketball video game. And I believe the plaintiffs in that particular case were awarded as much as $5,000 each, and it was to be put in trust and held for that particular athlete. Then we have, in 2021 again, we have the NCAA v. Austin. And again, as my colleague has stated, Austin was actually not about NIL, but it was about adding certain benefits to the scholarship package for athletes. So there were some institutions that, some of these collegiate athletes will go to college and room and board will be paid for, but they have to pay for everything else. What Austin basically said is you can package these scholarships to encompass other things that athletes may need, such as computers, if they're, let's say, in the IT program, or if they're, let's say, an athlete in the instrument or wanted to be a musician of some sort. You can package the scholarship so this athlete can go get a, grand piano or something of the nature. And so that ruling came out in June 21 of 2021. And it did lay the framework of how the court might assess the NCAA NIL restrictions under antitrust. June 30th, 9 days later, the NCAA passed what they called their interim NIL policy. And what that says is athletes can now engage in NIL activities if they follow state laws where their school is located, and schools must ensure these activities comply with state law. As Nussbaum has also alluded to, the feds have yet to regulate this, so they've punted to the states to regulate NIL. Athletes in states without NIL laws can still participate in NIL activities without breaking NCAA rules, and athletes are now allowed to seek professional service providers for their NIL activities. The effect of the interim policy caused states to amend or repeal NIL laws. State laws were more often restrictive than the NCAA policy, so some states repealed NIL laws entirely, i.e. Alabama. Other states amended NIL laws to remove certain restrictions and or provide schools more control and flexibility. Current NIL trends: over 30 states have NIL laws with often similar but varying provisions. 8 states have proposed legislation related to NIL. And Alabama is, in fact, the only state to repeal the state's law on collegiate student athletes profiting off their name, image, and likeness. And the only reason why Alabama did that is because I think it was maybe in 2006, they already had something on the records that says athletes can get paid in a roundabout way, if you will, for their name, image, and likeness. Current trends continued, and I think this is fairly interesting. High school sports are currently navigating the complexities of NIL. There are currently 20 states that actually allow high school NIL deals. Michigan will be the 21st state to actually allow NIL deals. And I think it was in the news maybe a week and a half ago that Gretchen actually said she's okay with it. But the bill has been proposed, and if it passes the Senate, then Michigan will be the 21st state to allow high school players to take advantage of NIL deals. And unfortunately, the St. Joe and Washington and all the graduates here in the state of Indiana does not currently allow NIL monetization, for high school sports. So here's some examples of athletes or activities for student athletes. While it was prohibited in the past, athletes can now be paid for autographs, memorabilia, attending camps or hosting camps, personal appearances, merchandise, NFTs, blogging, etc. Being a Buckeye fan, I wish this was in place maybe in 2012, when we had a couple guys that were actually suspended for trading paraphernalia for tattoos. And I say that for one reason and one reason only. There were only 2 undefeated teams that year, Ohio State and Notre Dame. Unfortunately, we were banned from playing in any bowl games, so Notre Dame played Alabama that year in the national championship. But that should have been us. These are activities that the NCAA has said that athletes are actually banned, that are prohibited from their NIL activities. And I think that, gambling, tobacco, alcohol, controlled substances, lewd behavior and material, and any other product or service inconsistent with an institution's religious values. I've done some work for athletes that attend the University of Notre Dame. and the University of Notre Dame has restrictions around their religious values piece. Pros and cons. The pros, I think NIL can relieve the emotional stress of those who must raise funds on their own. And I think that's specifically key for, your walk-on or your D3 athlete who only gets financial aid and may not get a scholarship for certain athletics. Athletes with strong media presence, I think, as you alluded to, the gymnasts from LSU, they have a high earning potential. Some of the cons, athletes may switch their focus from academics to attending a school where the NIL market is booming. And again, as an Ohio State fan, Quinn Ewers is now the quarterback at Texas. He came to Ohio State, did a year at Ohio State solely to be paid $1 million in NIL money, and he eventually transferred to the University of Texas. Male athletes overall have more opportunity for significant earning potential. High schoolers, in fact, might start drifting toward powerhouse sports programs instead of pursuing their academics. And that's the end, and we have left about 9 minutes for questions. Judge Woods.
Ms. Buari, as it relates to electronic cards and their former college game day series for basketball and football, I heard the football series is being revived in 2025. Have you heard that as well?
I have, and I think what the NCAA has said is they're going to stray away from the name, image, and likeness. So the universities have allowed the EA Sports to use the university's name. So they can license the name, they'll license the logo, but they can't use the name, image, and likeness of the players, right? So you might get a guy who's number 15 on a team in the game that doesn't resemble number 15 on the team in real life.
Is there discussion, will those players have similar attributes to the player that would formerly be named image and likeness? And will the college players benefit at all from the EA electronic sports?
So I'm not sure about the attributes, but the reason they're not going to have the athlete, at least from a name, image, and likeness standpoint, resemble the actual athlete in college is so they don't have to be. But that was part of the deal for the EA Sports to actually go back into a deal with the NCAA.
But in the program of the design, that you can modify the players however you see fit, from skin color to size to attributes. So in theory, your gamers will have an end run around that, won't they, Mr. Buari?
And I think you're correct, Your Honor, but I think the idea is that the NCAA itself is not doing a deal with EA Sports. And again, I think if EA Sports creates their game, then they create the game. The end user can then, of course, modify, but I think the NCAA is worried about paying these athletes, not whether or not the end user is going to tweak to resemble that.
Thank you, sir.
Shannon, how are you involved? Do you represent Notre Dame athletes? I mean, what's your involvement?
I do. So I was fortunate enough to represent a former basketball player for the University of Notre Dame. We actually represent the family, and it kind of fell into my lap. But he was experiencing NIL deals, and so P and I, so I can't take all the credit. P and I, of course, worked and sat down, and we kind of looked through what the rules, regulations, etc. are. And again, this was at the University of Notre Dame, and it was basically just reviewing some of the agreements, making sure the athlete can actually meet the requirements of some of these agreements. And from that, it's kind of blossomed to where I represent, I want to say maybe 4 or 5 collegiate athletes.
So these agreements are with the collectives?
They can be with the collectives, or they can be with certain companies. I mean, I've reviewed agreements from, let's say, Bazooka Joe or Top Straight. That'll say, hey, if you do X for us, then we'll do Y for you.
So what are they? They're the intermediary between the athlete and the collective?
So it's not also, I don't think the deals always have to be with the collective. I think the collective is a certain piece of it, but I think the interim policy said these athletes can now go out and do deals with any company as long as it's not a prohibited act.
So any advertising company can come and hustle these athletes?
Correct. I mean, I've seen stuff where, an athlete would make so many posts on Instagram with a particular product in view, and, you make 10 posts and you get X amount of dollars for those 10 posts.
So what, besides cash, what other kinds of ways are these athletes being compensated? I mean, I know pickup trucks is one we heard about, but what other kind of things have been offered that you're aware of?
I've seen cash and I've seen products. right? So I'll say, hey, you know, I know you're at THK, but if you want to take 10 photos with an AAK polo on, we'll pay you X, right? I mean, I've seen cash, I've seen products, I've seen services, and I take that back. I've seen, like, Boys and Girls Clubs request athletes come and do speaking engagements, and at the conclusion of the speaking engagement, they will pay them a certain amount of money.
Doesn't this just promote the Power 5 schools? I mean, they're going to get all the top talent in the country.
So I think that's where that federal regulation comes into play. One thing I personally disagree with how it's run now, is that the NCAA did away with that 1-year requirement to sit out for transfers. I think if they implement that, it may prevent guys and gals from just jumping ship. However, I think I think that's why the collectives exist, right? Because I think, let's say, Valparaiso University's men's basketball team, for example, may have a collective group of donors that can give a start, maybe 1 or 2 deals that they might not be able to get to Alabama or vice versa. So I think that's where those collectives come into play. But I do think there needs to be legislation to curtail that.
Not every school has collectives, though.
And
So you
sure,
don't have to have collectives, you can have Instagram followers,
Oh, sure.
like, and as long as you are getting some type of, like Colorado got huge because Prime went there, obviously, but all of those kids had followers on Instagram instantaneously, and they were nobodies beforehand.
and then I think, you know, I mean, to be completely honest, the likelihood of somebody going to a smaller school, if they have that type of crowd anyway, is probably sleeping. Right? I think about LeBron James. I mean, yes, he's at USC. There's probably no way he would have ended up at, you know, D2 and D3 school.
Mario, the collectives are separate from the schools.
Right.
Has there been any discussion about monitoring how much goes to each school, putting a cap on it, so that, you know, once say Alabama has $10 million, no more money can be spent on their players? Kind of like what they do in Major League Baseball when they have caps.
So not to my knowledge. And again, I think because outside of that whole collective piece, most companies are doing deals directly with, let's say, the athlete's representative, right? So I think at that point, I think a company could throw as much as they want to at that particular athlete or those athletes in general.
So isn't that going to encourage Wild Wild West?
That's why we're here. Well, and I think it will. And I think that's why there will be federal regulation. I think that's why there will be ample hearings on ways to curtail that.
Yeah.
That's the competitive balance issue with regard to scholarships. Same principle can be applied to the NIL money too, putting limits on that. But that's going to require federal legislation because certain states have the legislation right now and they differ. So the schools in those states are playing by different rules than schools in other states. So that's why the need for federal legislation is so important at this particular point.
Is there a significant, have you witnessed a significant advantage for the private companies versus the collectives? You know, is an athlete going to be better served by going to a collective versus an outside advertising company is what it is, or they're part of it, they're innovative in that.
The guy from the Grove said, the Grove is is affiliated with Mississippi. It's not Mississippi, but it's
Right.
It's 80% of the NIL money is through collective.
Yeah, but what stops an outside, this Bazooka Joe, I think it is, a couple of former basketball players, so Ben Harbor or something, close by, they were here. What stop, I mean, can't they get more money?
Nothing stopped.
Yeah.
Nothing.
What's your educated guess on this issue of the student athletes becoming employees? What's your educated guess?
I think there will be legislation that will preserve the status of students as non-employees. I think they'll be exempted from the statutes. But I also think, and Jack Swarbrick is a big advocate of this, is that there will be some sort of collective bargaining between some representation of there'll be non-union, but it'll be representation for student athletes and their particular schools, whether that's legislated, that there has to be insurance, there has to be scholarships that are guaranteed, because some schools, if you get hurt, your scholarship's gone.
Right.
You know, lumber schools, Notre Dame's never done that, I'm sure other schools have never done that, but there are schools that do that. I guess we're getting to shut up.
It's time to see the Notre Dame fight song for Shannon.
Well, I guess we're actually on stage left.
No, he would hate the Michigan.
That would be-